Hello, like to welcome you to the Our Revolution Helena TV program. My name is Frank Kromkowski. I'm one of the members of Our Revolution Helena. Our Revolution Helena has had this TV program for a couple of months now, and this is our 11th program. We've had topics like gun control, single-payer health care, the health care crisis in the United States, the need for better tracking of campaign finances and dark money. And that all flows out of our concern that as we work in Our Revolution Helena for reclaiming democracy in the United States from the many challenges that occur. And today's topic will be dark money in politics. The occasion for us getting together is that a film called Dark Money by Kimberly Reed from Helena and New York City will be premiering in Helena August 10th and then running through August 16th. One of the people who is in that film is our guest today. It's retired Supreme Court Justice Jim Nelson from Helena. He was a Supreme Court Justice for 20 years until January 2013 when he retired, but he's continued to be active. And he's a tremendous resource for information about dark money in politics, the legal questions that arise, as well as the other questions that some people have about what happens. So I want to welcome Jim to our program.
Thank you, Frank. Glad to be here.
One of the things that always arises in conversations about dark money is something that has been called Citizens United. And a lot of people say, well, what's wrong with Citizens United? It sounds like an innocuous term or group or whatever, people getting together. But there was a Supreme Court decision called Citizens United. What was that all about?
Well, let me say that Citizens United is probably one of the most pernicious United States Supreme Court decisions that's ever been handed down in terms of the damage that has been done to our democracy and the damage that will probably be done in the name of that case probably for many years. The case, the decision of the Supreme Court was handed down on January 21st, 2010. So let me tell you a little bit about what the case was about. The opinion was over 95 pages long, so this is going to be a very short and dirty explanation of it. Citizens United was a wealthy nonprofit corporation that ran a political action committee with millions of dollars of assets. The corporation produced an anti-Hillary Clinton ad, and they wanted to air that right before the primary election in 2008 when she was running for president against Barack Obama. There was a law that had been passed by Congress in 2002 called the Bipartisan Campaign Reform Act of 2002, and that act prohibited certain electioneering communications within X number of days of the primary and general election. Citizens United challenged that act as being unconstitutional. And the case made its way to the Supreme Court. The Federal District Court upheld the act, so Citizens United challenged it before the U.S. Supreme Court. Now the only issue that was before the Supreme Court was whether Citizens United had a right to use the funds from its general treasury to pay for broadcasts during the 30-day period that was prohibited under the Bipartisan Campaign Reform Act. And the court could have disposed of the case on that very narrow basis. But what the Supreme Court did in what can only be described as an act of gross judicial activism, the court sent the case back to the district court with instructions that it be rebriefed on the question that the Supreme Court really wanted to decide. Now, it wasn't reheard by the district court, simply rebriefed by the parties. So then, having before it the question that the court really wanted to answer, and that is whether or not the Bipartisan Campaign Reform Act was facially unconstitutional. And when we talk about facial unconstitutionality in the law, that simply means that the law is basically unconstitutional for any purpose whatsoever. That's the question the Supreme Court wanted to answer, and of course the Supreme Court answered it by holding that the act was facially unconstitutional as a violation of corporate political free speech. The court did uphold the act's provisions requiring disclosure, but as for the ability of Congress to limit campaign expenditures by corporations to limit free speech, the court held that was unconstitutional. Now it's interesting, there were two primary premises that the court relied upon, and let me just go over those, because in some ways those are really seminal to any discussion of Citizens United. First, the court held that contributions made directly to a candidate engendered corruption quid pro quo. And the other idea is, I give you money for your campaign, I effectively buy your vote. Back in the day, I think they called it bribery. But anyway, the court called it corruption quid pro quo. The court said, however, that that contributions made on behalf of a candidate, you got to watch the wording, not to a candidate, but on behalf of a candidate, through political action committees, were simply a method of instructing the public or enlightening the public about the candidate or the issue that the money was being spent for. So that was premises number one. You can't give money to a candidate, but you can spend money on behalf of a candidate. And I think most people would understand that candidates know very well who is spending money on their behalf or against them. So I don't frankly know what the Supreme Court was trying to do there. The second premises, however, even probably more interesting, is that, and the court relied on a 1976 case called Buckley versus Vallejo. And the court held that money is actually a form of speech. So if you carry that to its logical conclusion, the more money you have, the more you can spend, the more speech you buy, and therefore the more speech that you have. So if I have a certain amount of free speech as an individual, you can imagine that a super PAC that can spend $20 million on slick TV ads as a form of political speech, how much speech that organization has. And that's the pernicious effect of Citizens United. It allowed a huge influx of money into the political process. And although the court upheld the disclosure requirements, there's more loopholes in that than a Swiss cheese. And the effect is that we have what's called dark money, which means that the contributors of the money for the PAC ad, for example, are not known. And we have what's called gray money, and that's just another loophole where, and corporations use this a lot, they like to hedge their bets, so they give money maybe to both sides. But they give their money to some trade organization or some other organization, and that's the organization that actually spends the money or the money for the ad. So you've got this money basically that's non-transparent. We don't know where it's coming from, but we're talking tens of millions of dollars. It's huge.
Yeah, and with all of that money then being flooded into not just Montana, but all across the United States, a crisis occurred in so many places because that money was dark money in the sense that maybe you could figure out who was behind that money, but probably not, in many cases at least.
Yeah,
and so it wasn't clear who was spending these millions to attack Judge Jim Nelson or Frank Krimkowski or supporting in that sense.
And usually you see these ads on TV where they're sponsored by Americans for Great Government. Well, that's the last thing these people want. They don't want great government. They want to promote what's good for the corporate bottom line. That's basically what it's all about. And that's, but this Citizens United effect is what we call it. This dark or gray mega money that's involved in politics. It's driving American politics right now. And the thing that's very of concern to me as a former judge, it's driving judicial elections. And we can talk about that if you'd like, but it's most states elect their judges. And Montana's last three contested elections for the Supreme Court, Montana Supreme Court, have all been at or well over $1 million. And that, just a few years ago, was absolutely unheard of. But that's going on all over the country. And while Montana may, well, in the last, the Sandifer race, there was $1.8 million spent. When you compare that to races in Indiana and some of these bigger states, that's chump change.
Mm-hmm.
But it's driving these judicial elections, and I can kind of sum up at the end of our program about how dangerous that sort of thing is. And if you think that money isn't involved in the federal appointments, think again. That there was, I think, one donor who gave $26 million to promote Justice Gorsuch when he went on the court. And all you have to do is follow the money in the current appointment of Judge Kavanaugh, and you're gonna see tens of millions of dollars spent by the Koch brothers, these people that want him on the court. And they want him on the court because they know his judicial philosophy is to support the thing that's near and dear to their heart, which is the bottom line.
I'll come back to that in your maybe suggestions for some remedies, but I want to go back to the film Dark Money, which is going to be premiering here in Helena August 10th. And I know that in that film, a famous case in Montana is highlighted. It's the case of Senator Art Whittick, who was the head of the Senate in the Montana legislature. And Jonathan Modell and others pursued a prosecution of Art Whittick, not for millions and millions of dollars, but for not disclosing certain funds that were in fact used for their campaign, and even in-kind services that were used for that campaign. And that went to the Montana Supreme Court as well, in some respects. And I just wonder if you have any thoughts about that whole Art Whittick
Well, that
issue.
whole thing and was involved in the disclosure part of Citizens United that the Supreme Court are allowed to stay in effect. And as you correctly point out, Mr. Whittick failed to make disclosures as required by our campaign finance laws, and he was prosecuted and found guilty by jury. And the case went to the Supreme Court and appealed, and the appeal was upheld by the court, and he was, I think, sanctioned by the disciplinary process for violating those laws. But the disclosure part of Montana's campaign finance laws have been challenged several times. So far, they've passed muster and been upheld. But I'm very concerned that, especially with current administration and what's going on in Washington, I'm very concerned about the disclosure part of those being taken up to the Supreme Court again, and the new Supreme Court may find those to be unconstitutional as well. Clarence Thomas, Justice Thomas, in his concurrence to the Citizens United case, kind of threw out the gauntlet. He said, my concern about disclosure laws is that if people have to disclose who they are when they give money, it's chilling to their free speech.
Mm-hmm.
Yeah.
Yeah.
I think that's where it's going.
Well, not many people have a really high opinion of Clarence Thomas as a judicial scholar, so I wouldn't be surprised that you're accurate on how you're reporting it. One of the things that I remember very clearly is that 1 year after the Citizens United decision, there were a group of 50 of us who, on January, what date? That 20th of the year after Citizens United, were on the steps of the state capitol here as a way of thanking the Montana Supreme Court for attempting to preserve some of what was in Montana's law against Citizens United. I wonder if you could just say, what was that Montana Supreme Court decision and how it was overturned by the Supreme Court?
There was a case called Western Traditions Partnership versus the state. And Western Traditions Partnership, which is now, I believe, Americans for Prosperity, kind of morphed into that, challenged Montana's Corrupt Practices Act, which was originally enacted in 1912. And they challenged the fact that Montana law limited campaign contributions in respects that they didn't like because they wanted to spend a lot of money in these races. The Montana Supreme Court upheld the Montana law, basically took the position that Montana had a lot of expertise in corruption from the period of time when the 1912 laws were enacted, and that they had a compelling state interest to uphold our laws, even in the face of Citizens United. The Supreme Court, Montana Supreme Court decision was 5-2, and I was one of the two. I filed a very lengthy and very vigorous dissent on the basis that, having read the Citizens United decision and studied it, I knew that there was no way that Montana law could pass muster over the top of the decision. Citizens United was an extremely broad, sweeping decision, and I felt that there was just no way that we could, in good conscience, say that Montana law should be upheld in the face of that. So the decision was appealed to the U.S. Supreme Court, and in a summary decision, the Supreme Court did two things. They overruled the Montana Supreme Court decision, which I figured they would, but they also made the Citizens United decision applicable to the states. So after that, Montana's Campaign Practices Act pretty much went down the drains, with the exception of the disclosure provisions. It was an interesting dissent because I not only raised Cain with my own Supreme Court, but I spent a whole lot of time raising Cain with the U.S. Supreme Court for the decision that they'd made too. So it was kind of a career highlight. I got to raise hell with two Supreme Courts.
I'm glad you could tell us that story. Now, we just have 2 minutes left, but I want you to come back and say, okay, this Citizens United case is pretty devastating and disastrous for letting the floodgates of money into politics, affecting ordinary citizens who don't have that kind of money. What can we do about that in your idea?
Well, there's probably only two things that can be done, and that is to have the case reconsidered by a future U.S. Supreme Court. Given the makeup of the present court and soon to be, I think, even stronger, with assuming that Judge Kavanaugh is approved. I don't think that's going to happen for a long, long time. There are a number of organizations around the country, one of which I'm affiliated with. It's called American Promise. And there are attempts to draft an amendment to the federal Constitution to overrule Citizens United in that way effectively, and to restore some of these rights that corporations enjoy, make those solely for human beings. And there are a number of, in fact, Montana adopted a resolution, I can't recall exactly the year, it was after Citizens United, stating that our congressional delegation had to support such an amendment. Our Senator John Tester did and has very vigorously supported that. Neither Senator Daines nor Congressman Gianforte have supported that, however. But there are a number of states that have joined in that effort, a number of cities and towns across the country. So that's building, and presumably, maybe, hopefully in 10, 15 years, that will come to fruition too. It's very hard to amend the federal Constitution. So it's going to be a long, hard haul. But
Yeah. Well, youngsters like us, I'm sure, will be in the battle for the next 20 years or so. And so we may be able to contribute to that before we pass over the horizon.
I don't think I'll see the end of it very quickly.
So, but possibly. Yeah. So we never give up in the face of these difficulties.
Let me say one thing in just the brief time we have left, and I think this is probably going to be somewhat controversial, but I think it's very important. Citizens United isn't history; it's a fact of life. And fast forward to today, and I want the viewers to think about this. Our president basically owns the majority party in Congress, and that's accepted pretty much as fact. Congress has exhibited the tendencies of ovine lick spittle. It's pretty much caters to every whim that the president has. The point I'm trying to make is not to badmouth Congress so much, but Congress has failed to perform its duty of being a check and a balance to the executive branch. And that's one of the fundamental parts of our Constitution, is the system of checks and balances. So Congress has failed totally in doing that. If, as I expect, the president will secure the Judge Kavanaugh to be on the court, that will put a solid 5-4 majority in his favor. And he will effectively control the third branch of government, the judiciary. And that means that there will be no system of checks and balances left. One of the most fundamental protections in our Constitution will not operate anymore, and that's the system of checks and balances. What I want people to think about is, do we want a system of government where one individual with monarchical tendencies, do we want that person running our government? And the basic definition of that kind of government, if you think about it, is a fascist regime. I had an email from an individual that was, it was kind of stunning to me when I got it. And the individual said, she said, if you were living in pre-war World War II Germany right now, what would you be doing? And that really gave me concern and pause for concern. So I don't know. I think people should be thinking along those lines, because if we want a constitutional democracy, with a strong system of checks and balances and courts that will protect the fundamental liberty interests and rights that the Constitution guarantees, we've got changes to make. We've got to think about that very seriously.
Well, ending on that challenge to all of us who are understanding what you're saying about the dangers to democracy that have occurred because of Citizens United and the subsequent political decisions by President Trump. I want to say that's all the time we have today, but I want to thank you, Jim, for sharing your thoughts with us and your understanding of the history and the law. And I want to thank all of our readers for participating in our program today. And I invite you to be part of our Revolution Helena meetings every 2 weeks, August 9th and August 23rd, and every 2 weeks after that over at Plymouth Church. Thank you very much for watching today, and hope to see you again.